Hi, thanks for coming. Bear with me as on the presentation here, it's not my stuff, but looks like we're going. So they asked me to talk today about top 10 mediation tips and tricks, how to prepare yourself and your client for mediation. You can see I crossed out tricks because we're not tricking anybody here. Mediation is a great method for helping resolve disputes and settle lawsuits, and there's no trick to it. There's work and preparation and understanding what you're doing and wanting to get your case or your dispute resolved. How many folks in here are lawyers? Okay. And so can I assume the rest of you are non-lawyers? All right. Lawyers, those of you that have been involved in mediations, how many those of you who've been in mediations 1 to 5 times, can you show me hands? 5 to 10, 5 to 9, more than 10 mediations. Okay. The non-lawyers, if you've been involved in mediation before, let me know. Have you been involved in mediation before? Okay, was that a positive experience? Anybody? Was it a good experience for you? You get your dispute resolved?
In one case, yes, and in another case, no.
Okay. The case that you didn't get it resolved, was it still a worthwhile effort?
Oh, I would say mediation is worthwhile effort, no matter how it turns out. If it turns out bad, that tells you something.
Right. Okay. That's right. That's right. Good. Well, so I'm glad to have you here because I feel like it's a worthwhile effort. I'm a lawyer, but I haven't litigated in years. I've had a mediation practice for years. So all I do now is I help lawyers and their clients settle disputes. Sometimes their disputes before they're in litigation. Most of my work is cases that are already in litigation. Okay. And that's what most of my talk is geared to, because they asked me to talk about preparing you and your client. And so when I think of someone with a client, I think of a lawyer. I'll try to I think you'll still get something out of it even if you don't have a lawyer and you're not representing a client. But feel free to raise your hand and ask me questions. My PowerPoint, I hope you got the handout. It's just basically the PowerPoint with some notes, with some space to write some notes on it. PowerPoint is nothing fancy for us today. One of the things I should let you know is that I'm not discussing family law mediation. I don't really know the law in family law, so I haven't done any family law. So most of my work is focused on civil litigated cases. And these cases can run the gamut of all types of cases. The mediation process is similar to the variety of cases. Sometimes one part of the process is emphasized more than another, depending on the case, and I'll get into some of those details. The types of cases they run from are from personal injury cases to neighbor disputes over trees or fences, or to easements, to business disputes over contract issues or other business issues, employment cases. I mediate real estate cases, landlord-tenant cases, probate and trust disputes. So it's really the gamut outside of family law, or something that would be very specialized, like business, like taxation or something like that. So I'm pretty much a full-time mediator. I don't represent anyone. I don't represent clients. Used to, as I mentioned. In my work as a mediator, it's great because I'm a neutral now, and I get to see the work from lawyers from both sides. And so I see a lot of stuff that's done right, and I see some stuff that could be done better. And that's really helped me. And some of those things will have made it into my talk here today. I'm going to start off with the basic. The basics to prepare you and your client for mediation. It's really just fundamental things, and I'm going to go over some of those. The lawyers, you may have already, and even non-lawyers, some of this may be obvious, but if you pick up one or two nuggets of info, I think that'll be worthwhile. So the first thing we want to do is you want to choose the right time to mediate. You don't want to mediate a dispute or a lawsuit too early. A lot of mediators will espouse early mediation to save money later on down the road, but for a lot of reasons, an early mediation it can be ineffective. One of the things that makes it tough is if you have a case with a lawyer. Lawyers are not comfortable making decisions without full information. We're used to doing discovery, getting information from the other side, and if it's very early in a lawsuit, you haven't done discovery, then the lawyers are unsure about how the facts of the case are going to turn out, and hesitant to make decisions. It makes it tough. Similarly, in a pre-litigation dispute, if you don't know enough information and if it's very early in the dispute, a mediation session can be effective, but it can be effective without actually resolving the case. Sometimes you want to get together with the person you're in dispute with, say you don't have lawyers and you're arguing over trees or fences with your neighbor. It may take a few sessions of getting together and exchanging information and learning about the dispute from the other side. That's what mediation does, is you can learn a lot. It's open communication. And so the idea is to learn about the other side, let the other side learn about your case so that you can find a compromise to get it resolved. And so if you do it early in a non-represented case, it's difficult to get it settled, but it may be worthwhile to do several sessions. I've seen cases in the litigated side where the parties attempted to mediate early, but things, for instance, I had a personal injury case where the defense counsel didn't really know the plaintiff's case yet. And so the defense counsel hadn't really properly advised his insurance adjuster because he didn't know the plaintiff's case. In these personal injury cases, it's very insurance dependent. The defendant has, if it's an auto case, has auto insurance. And the adjuster had set the reserve too low because of the case that the defense counsel had told his adjuster what he thought the case was. So we got the mediation. The plaintiff said, no, that's not my case at all. And the adjuster was not prepared for that. Yeah, I'm looking at my note here of another a separate case where it had changed lawyers. And the second lawyer saw theories that the first lawyer didn't see. And again, the adjuster wasn't prepared for that. Hadn't viewed the case that way, and the mediation went nowhere. If the case is expert, if it's a very complex case, you're going to want to do discovery. If it's going to be expert dependent, you're probably going to need your expert witness reports, but you can get the case settled before taking expert depots, is what I found. For your lawyers, if there's an MSJ that is on file or is going to be filed, you have to assess the risk of winning or losing at that. It's very difficult to settle a case when an MSJ is pending because the defendant who did the MSJ, for the non-lawyers, is a motion for summary judgment that would end the case. The defendant that brought the motion for summary judgment thinks they're going to prevail, so they think the value of the plaintiff's case is very low. The plaintiff, of course, thinks that they're going to prevail over that motion for summary judgment, and they want full value for their case. So it makes it very difficult to settle those. We can settle them. It depends on the area of law. Some areas of law, an MSJ is just filed almost de rigueur every time, and both sides kind of acknowledge it as that, and we can get them settled in those situations. So it depends on the case of how early you're going to do it, but in a litigated case, you want to have at least your basic discovery done. If there's going to be experts, it's best to have experts exchanged if it's really going to depend on the experts. If both sides don't have experts and one side just thinks they're going to get a little extra emphasis on their case with the expert, and they've got that expert in the background, you don't necessarily, that lawyer may not think they actually need the expert's report and have to exchange that. And so sometimes that'll work as well. You always want to be aware of insurance coverage for both sides, actually. I think the lawyers here know that to find out how much coverage there is, if it's a case that depends on insurance coverage, it's good to have the defense also needs to know how much coverage their client has. If they don't know, we can find out at the mediation. We can always make phone calls at the mediation and get a hold of the insurance company and so forth. Sometimes there's more complicated issues. If it's a business, they might have what's called self-insured retention up to a certain level, and then after that, the insurance kicks in. Well, the insurance company may be interested to know how those early negotiations are going, even though it's not their money yet. If the negotiations get to a point where it increases over and above what the business is self-insured to, then the insurance is going to have to kick in. So they want to know where that's going. Those are a little more complicated insurance issues. But it's important, even if in a litigated case, if the discovery hasn't revealed what the insurance is, that we exchange that information before or at the mediation. Open exchange of information is, again, what mediations are about. I did number these. We're on number 3 because I tried to kind of make them 10, just depending on where I put the numbers. But so for the third tip here, don't be afraid to contact the mediator beforehand. In my practice, I usually ask for mediation briefs or statements about a week before. After I've received both sides and I've read them, I'll contact the lawyers. But as a lawyer, don't be afraid to contact me earlier once we've arranged, you've decided to mediate, or we've arranged and scheduled, calendared the mediation. There's no rule against ex parte communications. For your non-lawyers, ex parte communications is like talking to a judge. One side can't talk to the judge without the other side present. In mediation, there's no rule against that. So you can talk to me about your case beforehand. Again, it's all about openness. And when we talk, I'm going to ask you, is this confidential or not? Usually you want to let me know things about your case that then I can help you inform the other side about your case. When you talk to me or the mediator before the case, don't be afraid to talk about the substance of your case as well as procedure and calendaring and so forth. Let them know the good things about your case. You want to get the mediator's ear, I think. I would want to. Mediators are human too, so the first thing I hear, oh, that sounds good. And then I hear the other side of the case. I said, oh, now I see. But it's good to, for you where you're advocating for one side to pitch your case to the mediator early on. Also, don't be afraid to talk to the mediator on other types of disputes that might not be the entire case, but say you have discovery disputes or some other dispute with the opposing side, with opposing counsel. I can help with that before the mediation and get those things resolved. I work as a discovery facilitator for some counties. I've done a ton of discovery, so I can always help with that stuff as well. And other smaller disputes sometimes come up. I have, especially if it's a new theory of the case, what happens sometimes if the lawyer has added, let's say the plaintiff has added a new theory on which they want to recover. Maybe they haven't yet amended their complaint, or they've amended their complaint, but it really hasn't been reported to the insurance adjuster. They don't really know the ins and outs of it. If I don't know, you want to let me know early that I've got a new theory, this is going to change the nature of the case, so that I can get a hold of the other side, normally the defense, and let them know, plaintiff has a new theory, he or she's going to send you some information on it. so that when we get to the mediation can be effective. Because if you get to the mediation and it's a brand new theory of the case that the other side hasn't heard, I can't talk about this now. I have to evaluate it. It's got to go back to the insurance company. They have to round table it. It has to go before committee, etc. So don't be afraid to, again, openness. Let me know beforehand if you change the theory of your case. Okay, what do we got next? Have witnesses, experts, and evidence ready. This goes without saying. You want to make sure that you've got, the right witnesses, the right experts, demonstrative evidence, that you've mustered all this stuff together for the mediation. And it's good to have, if you don't have someone there, have contact information. If you have a witness, have the contact information in case there's a dispute about what the witness has to say. Or you have an expert that's going to be crucial, have their contact information. We can call there's no rules on what we can and can't do. We'll call the expert, find out what they say. We'll put them on a speakerphone, or you can have a conversation with the expert, make sure he's going to say what you want, then we can talk to the other side about it. So have all that stuff, all your evidence ready to go. This again seems obvious. Ensure that the decision maker is present in the room. In personal injury cases and smaller personal injury cases, the insurance defense attorney may ask that the adjuster be present by telephone. I don't prefer it. Plaintiff attorneys often don't like it. I have settled cases, smaller cases, where the adjuster is only present by phone. In a bigger case, you want to have the insurance adjuster actually there, not on phone standby. You want to have them present so they can see the adjuster. So they can see the plaintiff, the other side, and you can talk to them directly. If you have an individual person as your client, they may want to have their wife, their husband there, or a friend there to give them emotional support, or someone to bounce ideas off of, other than just their lawyer. And especially if it's an emotional case, having someone there to give them emotional support can be a good thing. All right. Provide a useful mediation brief. Okay, useful means included. If you're the plaintiff, include a demand for settlement. That's how we got to get. The best way to get started is that the plaintiff has included a demand for settlement and has gotten the brief to the defendant in a timely fashion. The defendant can then make an intelligent reply in their brief, and they could even include their response to the demand with their offer. And now we've gotten to the mediation. We get there for the session. We're already rolling. People are already thinking about it. So as a plaintiff, you should always include a demand. As an individual, you should know what it is that you want to get out of it. What's your bottom line? What's the most you're willing to pay, or the least you're willing to take? Or if it's a tree dispute, think of some alternatives of, can we trim the trees? What can we do? So you want to think about those sorts of things before the mediation. Again, it's about open communication. You want to let the other side know all your theories of the case in your mediation brief. You want to exchange mediation briefs with the other side. If there's something absolutely confidential, you think you've got a smoking gun on the other side, let me know privately. Send me a letter or a brief marked confidential, or call me and tell me it's confidential. And you don't have to. We won't let the other side know. At some point, you're going to want to use that. If you have some information you think is going to give you good leverage, at some point you're going to need to use it. Otherwise, you don't get the leverage out of it. But let me know, even if you're not letting the other side know right away. Obviously, put in the informative exhibits. We've been talking about personal injury cases a little bit. So, for instance, a personal injury case, include the police report. Recently, I got a brief on a personal injury case, and there were 3 versions of the event from the defendant driver, 2 versions of the event from the plaintiff bike rider, and also a version of events from an independent witness. The plaintiff lawyer did a really nice job in his brief in which he stated, there's 3 different versions, and he gave all the versions. One was in the police report, one was an exclamation at the time, one was at a later deposition. But then he also said, and the plaintiff has 2 versions, and here's the plaintiff 2 versions. So the plaintiff attorney was being open to tell me, even my client has more than one version of what happened. So that in mediation, we know this is going to be one of the issues that we're going to have to work through. So don't be afraid to, again, openness. Any questions so far about halfway through? Yes.
Well, I'm aware of a mediation I heard about. I don't know the parties, so they maintain confidentiality. But the person who was running the mediation, who was mediating, the matter didn't settle, and so he was caucusing with the individual parties afterwards, just kind of giving them some kind of parting thoughts. At which point, one of the parties disclosed this whole bunch of facts, et cetera, that he refused to bring out during the course of the mediation, and it was in part. It was kind of acting as a fishing expedition to see what the other party was going to do in light of the disclosures he was making. Does that make sense? I mean, do you?
I think he miscalculated. I had a mediation once that we spent all afternoon. We spent quite a bit of time. Each side, the party, not the lawyers. Each side, the party, just talked incessantly and had a reason for everything, and my job is to listen, and I was listening, and we didn't get very far, even though we were there for a long period of time. And at the end, one of the lawyers said, "Well, I was waiting till we got down to the last hour, and we could really start exchanging numbers, and when it would really happen." He says, "Well, you can't fake it, for 5 hours and then wait for an hour for it to happen an hour. It only happens that last hour if you've been doing the work leading up to it." And he had told me that afterwards. So in that particular case, it was too late. But in the case where what you're speaking of, it's if there's still time in the day, it's worthwhile to get both sides back to say, wait a minute, maybe we're not done here.
The party was not interested in mediating further. It was a very calculated and expensive effort to kind of do a fishing expedition, even though it was going to be, you just wanted to see what the other parties were going to do.
Okay. Fishing expedition. So the thought is that sometimes one side will say, let's mediate it so we can get all kinds of, and what they're really trying to do is get all kinds of information from the other side, but they don't ever really have any intent on settling the case. I've been in cases where I felt that's what they were doing, and as a mediator, I don't want to be, the vehicle by which they do that, and when they're not really trying to sell the case.
So what do you get? Do you get a mediation?
Well, if it's, you don't usually discover that early on, where they don't tell you that's what they're doing, right? It's usually after a case didn't settle, and I'm looking back at it. So, I try to figure out what was going on there, and that thought occurs. Yes?
Usually people that don't have an interest in settling and just try to get information from the other side, they're giving them offers and during the mediation, and they make really, unreasonable offers.
Mm-hmm.
At some point, I've had mediations where the mediator says, look, it's going to be this far apart, and we really have no interest in doing this because it becomes pretty obvious. They just said,
Right.
I'm either going to make a mediator's offer, or I'm just going to end it now and go through the rest and say, your opinion is 4 hours.
I've settled those cases. It really takes you get those cases where you think it's not going to settle because they're so far apart, and the statements that they're making, that one side is making, and maybe they're staying at a really high number or defense at a really low number, and you think, it's just not going to settle. I tend to just keep grinding away at it, grinding away, and I get surprised. Yeah.
So you made a distinction earlier talking about how parties were really chatty and talking about, and then you've got maybe lawyers taking a different tack. Speaking as an attorney, having been in a mediation where I could see the parties were just really talking and all this emotive, and you could tell they really want to settle. And opposing counsel's got it in his head that there's some bright line rule that he just. I walked away from the mediation thinking nothing screws up with mediation like a lawyer, because I've been in situations where it's clear that the parties want to settle, and what do you do where you've got counsel who's just scuttling everything?
So one of the things that I do, and I should have mentioned earlier when I was talking about engage the mediator beforehand, is I will ask the lawyer, tell me about your client. And what I'm trying to find out, and sometimes I'll ask directly, is how's your client control? Okay? Do you have control of your client? Then when I'm asking that question, really what I'm also thinking is the lawyer going to be, way out there, and it's really the lawyer who we don't have control of, but the client, because sometimes that happens, where we could settle it, but the lawyer, like you say, they have other ideas. In those situations, there's times where I will, and I usually will tell the parties beforehand, I may want to talk to your lawyer outside your presence. And that's what I'll do, is I'll talk to the lawyer outside of his client's presence, because I never want to embarrass a lawyer in front of his client. I never want to denigrate his theories, his legal theories in front of him. I may question their case, but I don't want to make him look bad or embarrass him in front of his client at all. So in those cases, I will talk to the lawyer outside the presence of the client and probe them, find out, see what I can find out. And if they're not going to settle the case that day, then we'll be done for the day. But I'll usually encourage them to stay and listen to their client. Good lawyers advise their clients and also listen to their clients. They don't just jam down their ideas down their client's throat. Because clients get emotional and they have other reasons sometimes of why they want to resolve a case, and it might be below what the lawyer thinks they should resolve it for, because the lawyer has legal theories and the lawyer's been in the situation, knows more. The client may have their own personal reasons, and so good lawyers listen to their clients. That answer your question? Okay. All right. Let's see. So, pardon me. Yes, your hand was raised. I'm sorry. How are we doing on time? We're okay. We're at.
I was here kind of near the beginning. But did you address the matter of whether you dealt with things like landlord-tenant or injunction relief in something with government attorneys as well as the private property owner?
I have mediated landlord-tenant cases. Yes, I'm not quite sure if that was your question.
What about injunctive relief?
Yes.
And that would be all right, not just money.
Right. I'm not. If it's something that's a bright line injunctive relief, let's say that it's either this side or that side. You have to understand, as a mediator, I'm not going to change the lawyer on the other side. I'm not going to be able to change their mind. Okay. Lawyers stick to their guns. They stick to their positions. They have to want to change. They have to see the light of the other side's argument. But I can't just go in there and somehow by force of will they're going to change the argument just for me. Okay. They have to want to sell the case too. All right. I'm going to move on. Where are we? Yeah, I've been talking about this. So again, it's not don't hide the ball in mediation. We're trying to take a break from the litigation to exchange ideas of how we can get the case resolved. Again, if you have something that's you absolutely is confidential, then let me know confidentially, and I won't let the other side know. Okay. I'm probably going to try to talk to the lawyer about using it, when would be the right time to use it, use that confidential information. But of course, I'll respect their confidentiality. Okay, so preparing your client for mediation. I've got a few more things to say on this. You need to understand whether your client really wants to settle the case or not. Sometimes people just like the fight, and it gives them something to do, and it gives them some excitement or some drama in their life, and they really don't want to be done with it. So you really need to find out if your client wants to settle the case. If you ask your client, well, do you want to settle this case? Often the answer is, and when I ask lawyers, do you want to settle the case? Often the answer is, well, yes, if I can settle it where I want to, in the range that I want to. Understanding that value or money or damages have to be resolved, but assuming that they can be, does your client want to settle the case? Okay. The best thing you can do for your individual client in preparing them for the mediation is to get them coming around that at the end of that mediation, they're going to be done with this case and it's going to be out of their life. She has to own the idea that she's going to settle the case. Has to be prepared to have it out of her life. And sometimes that's the issue, sometimes not. But you should be aware of that when you have individual clients. There isn't really one size fits all to preparing your client. It's going to depend on the client. You'll prepare different clients differently, and you'll obviously prepare your clients differently for different kinds of cases. The business person on a business case might want to just keep it very straightforward in numbers and facts. But that person has to understand that mediation is going to be a little bit more than just, the financial numbers, because there's a person at the other end of that who needs to work through whatever the issues are. On the other side of that equation, a personal injury victim, someone who's hurt in an auto accident, let's say, has to understand that the resolution is going to be money. That even though it's personal to their body, they got hurt, the resolution is going to be money, and that's all that our system can do, and that there will be a negotiation, and that it's going to be a back and forth negotiation usually. Okay, it's not going to be if the plaintiff wants $50,000 to sell their case, and they say, okay, $50,000. It's going to be negotiated from that. So the lawyer, obviously, not everyone's comfortable with negotiating, so the lawyer needs to really make sure that their client understands that's what's going to happen, and understands whatever you as a lawyer, your negotiating plan is going to be, and what your negotiating style is. People have different styles, different methods of negotiating, and so your client needs to be on board with that so that they don't start to get nervous during the process. They're going to be a little bit nervous to begin with. Some of the types of cases, if you have a neighbor dispute over trees or fences, that's going to be very emotional. If you have an easement dispute, it's going to be very emotional. You have a probate and trust dispute, that's usually among family members, and that's like doing family law. Again, very emotional. If you have an employment dispute, it's very personal to the employee, probably not as personal to the employer, but it can be. Sometimes they were close. And this has driven a wedge, and it's upsetting. At an employment mediation, you may have supervisors there, you may have former coworkers who were witnesses, and it can be personal to them and emotional to them. I talked about a personal injury case, even though it's a personal matter to the injured person. It's actually often less emotional in a personal injury case than in, say, a neighbor dispute or an easement dispute. A business dispute, can be very emotional to employees in a deal that went bad. If they're an officer in the corporation, a deal went bad, it's going to be personal to them because they probably were the architect of the deal. And they're going to have some ego. So when you prepare them, you want to probe in that direction, find out if they have a big ego, and if that's going to be a roadblock to getting the case settled, and work with them to get that, to set their ego aside in the interest of a resolution of the matter. So you have to know your client, see how she presents, and then you can decide how you're going to prepare them. You want to prepare your client possibly to make some presentation, either in a joint session in the beginning of the mediation or thereafter. Often mediations these days, the joint session doesn't involve both sides talking about their side of the dispute. It often talks about, the joint session often is very procedural, and then separate, I work with the separate sides, And then if we want to get back together jointly, both sides together, we can do that. And so if you have a client who you think will make a good presentation, you can let them talk. Sometimes they need to talk to the other side so they can feel like they've put their case out there, sort of had their day in court. If the adjuster, again, a personal injury case, if the adjuster hasn't met the plaintiff, even though the defense attorney has taken their deposition, then it's good to have them meet, say hello, maybe a few pleasantries, so that the adjuster can meet your client can meet the adjuster and make a good impression. Let's see what else. Yes, let's see. You want to, when you're talking to your client about whether to speak in the joint session, a lot of lawyers don't like their client to speak. They're afraid of what they'll say. But you want to consider if it's even necessary. Will it really help her case? Again, if she's already given a depo or the adjuster's already met her, that will inform your decision. In preparing your client, prepare that if it's going to be emotional to your client, it's going to take longer to prepare them. Yes?
Curious as to what are the considerations you run through when structuring the mediation as far as meeting jointly, meeting separately, what's your opening volley in terms of putting them all together in the same room at first?
What I do is in that pre-mediation phone call, if I haven't talked to the lawyers or the sides, if they're underrepresented before, after I get statements or briefs or we're getting close, I'm going to call them and I'm going to ask them how they feel about a joint session. Often, what I hear more than half the time, most of the time, would be, no, we don't need a joint session. My client doesn't need to talk. I don't really need to hear what the other side is saying. I already know their case. So forth. I said, okay, that's fine. Then what I do is a joint session, really to go through the process of the mediation and kind of housekeeping matters, sign the agreement to mediate, and so forth. Okay. What I'll do, I'll get to the mediation. I try to get to places early, and if, say, the plaintiff and his lawyer are already there, I'll go meet with them and start going over the ground rules or the process we're going to go through right then. And then when the defense comes, I'll meet with them and we'll get rolling that way and actually never meet together. Depends on the type of case. And sometimes, you want to keep parties apart. Sometimes the lawyers want to keep the parties apart if there's a lot of confrontation. And sometimes, and it's a hard call, sometimes when there is that lot of confrontation, as a mediator, you have to be a little bit comfortable with confrontation. And sometimes it's better that you get them in the room together to listen to each other civilly, try to each make their point to each other without a screaming match starting. Sometimes that can be very helpful. Let's see, where are we? We're preparing your client. So you'll need to prepare your client on the mediation process. I'm going to go over it in the mediation, but it's always better if your client has already heard it once before. Usually I've sent an email in my confirming email that goes through these things, and my mediation agreement has these items in it, and you should go through that with your client beforehand, so that they've heard it once, then they hear it the second time, and they get it a little bit better. They're a little more comfortable with it. You're going to let them know that that a mediator, I'm a neutral, but not a decision maker. That's important that they know, that we're going to try to work it out together. Should also let them know about the confidentiality clauses and the rules on confidentiality in mediation, which are really great, and that's what promotes the openness. Is the law protects what you say in mediation from coming out later in court. Okay.
So I just have a.
Yep.
So where do you meet in the neutral setting?
Sometimes where we have lawyers, a lawyer will offer their office, and if it's okay with the other side, we'll meet at that lawyer's office, rather than getting good thing I put the top on, rather than finding a completely neutral place. Most often we end up meeting in a lawyer's office because it's convenient for one side. The lawyer for the other side doesn't usually matter, and if their client is comfortable, if it doesn't matter their client, then we just go forward with that. Yeah. Not too often do every once in a while I run into someone who really wants to feel like they're in a separate place and not going to be hometown in the other side's office. Yes?
Do you ever have situations arise in which there's a defendant and a plaintiff, but the defendant says, well, we have to do this because I have this contract with a third party, and what do? Do you get the third party lawyer and client in? Or I see this idea of partnership by, say, San Francisco government with property owners over the way they're conducting rental decisions, and some of the decisions, there's not a taking exactly of the property by the government, but there is the condemnation by the government of what the property owner is doing.
Sure.
At the expense of the client, you see?
Right, right. So
What do you do in that kind of a situation?
So I can't really comment on the substance of a particular facts, because in your case you're talking about where there might be a third party, I need facts from all sides. If there's a third party that's important, we want to have that party there. If they have a lawyer, they're going to want to bring their lawyer. That's the short answer to your question.
Yes.
Is that okay? Okay. Oh, the last thing I have on preparing your client for mediation is the lawyers should also prepare yourself for mediation. And I like to think of it as taking a breather from the litigation. And so that as a lawyer, you come to the mediation stepping away from the stress of litigation and thinking more about how we can work this out. So that's important as well. All right. Know your numbers. Know the value of your case. Most cases come down to money. Some of them not. So we talked about some of those other situations, but the majority of cases come down to money. So you need to know the value of your case as best you can. Do a jury verdict search. Ask around other lawyers. Use, of course, your own experiences. Make sure you discuss with your client what your opening number is going to be. If you're a plaintiff, it's a demand. If you're the defendant, we call it an offer. And make sure your client understands what your opening number will be, and have a general idea, target of your bottom line. Some lawyers want to have a very firm bottom line with their clients before they enter. Some a little more flexible. I prefer flexibility because often when you come in with a firm bottom line, you end up going below that. If you're on the plaintiff side, you end up going below that at mediation, because you get to this gap where the plaintiff has come down, 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 the defendant has come up, up, up. You get to this gap. Somebody's going to have to give. Well, generally both sides have to give a little bit to get the case resolved. So you need to prepare your client for that. I think I mentioned before discussing, your negotiating style with your client and how you're going to negotiate the case. Sometimes, you'll move along in response to what the other side does. Sometimes you're going to make set movements. Sometimes you might make a big movement and then just try to hold there and make small movements to get the other side to come to your number. A variety of methods by which it transpires. All right. I think we talked about all those. As a lawyer, prepare your presentation. And even for a small case, I think it's worthwhile to put together a slideshow on your computer You don't have to show it to the whole room in a joint session. You can show it to me as a mediator privately, but it lets me know that, hey, you're ready to go. When trial comes, I've got a theme to my case. This is how I'm going to put my case on, and I'm ready to go. That shows me just that you're ready to go. You have confidence in your case. When I go to the other side, I want to see where they are on their case. Are they prepared? Are they going to be ready to go? After you've shown me if you've made a slideshow or a presentation and you've shown it to me, we can call in the defense counsel and show it to them. We can do it jointly. I said, show the mediator you have a case theme. When you're getting closer to trial, you want to have a theme for your case. I like knowing that you're ready to go, and this is the case you're gonna put on in front of a judge or a jury, and I think that gives you a strong position. Yes.
About this matter of a case theme, not for or against it, but I would like to see what you mean by a theme, by giving a few examples of themes that you consider themes.
Sure. A case theme is going to be the story that a lawyer is going to tell about his client's side of the case. Okay? That's the best way I can describe it, rather than giving you examples. That's up to the creativity of the lawyer for their own case.
It's a story, it isn't a 10-word statement.
Well, once you have the story, then you can distill that down to maybe a small statement. Yes?
I'll give an example because I was amused by it. A lawyer I was working with on the same side down in L.A. had a guy who had disability issues. He'd been working with a hospital for a long time in the IT area. And then when he had to take some time off, his boss made it very difficult. And I've been on this for a little while, and I engaged an LA lawyer, and his immediate reaction was, wow, this is a big, fantastic hospital. Their whole role, their whole job is to help heal people. So here we are with a hospital who heals people, but they can't heal this individual who needed their help. Now that's almost a one sentence. That was a reductio ad usefulness, so to say.
Right.
The one sentence after a lot of thought, I guess, would have been on my part. And his part, he just came right up with it.
Sure.
There's a theme so that it moves people. I guess he wanted to have the hospital think about that.
Yeah, great. Thank you. That's great. You distill it down to, like some people talk about an elevator pitch. Can you distill it down to, you could tell someone the theme of your case, what your case is about, in the length of a ride of an elevator. So. All right, so there's 10. I've got bonus for you. We should all be pretty happy, get to listen to me for another couple minutes. But this is pretty interesting. I can talk about settlement decision error. All right, so I don't know if they're lawyers, but there was a study written, and it was published in a peer-reviewed journal, and I've got the site for that if you want it. But the study was entitled "Let's Not Make a Deal: An Empirical Study of Decision-Making in Unsuccessful Settlements." Okay, and what it was is what they call a multivariate analysis of case outcomes after negotiations failed. Okay, so negotiations failed, they went to trial or arbitration. Was the outcome that they got at trial or arbitration better or worse than the last best offer they'd been offered in the negotiated settlement? So some researchers studied this, and what they found was that 61% of the time, and there's a lot of variables to this. That's why they call it multivariate analysis. So it may or may not apply because they had to take out, depends on the lawyers, the types of cases, the jurisdictions you're in, and so forth. And that's all statistics. That's why we have the field, I guess. What they found is 61% of the time, plaintiffs made an error in not settling the case. So that later on, 61% of the time the cases didn't settle, when they went to trial or arbitration, the plaintiffs got less than the last offer from the defense. And 24% of the time, the defendants made that error, and they ended up losing at trial more than what they could have paid to settle the case during negotiations. Okay. What was interesting was that although plaintiffs made the error more often, the cost of the error to defendants was much greater. So that when they went to trial, the mean or average, I guess, cost of defense error was over $1 million. It was $1,143,000 that defendants lost over and above the last negotiated offer. When plaintiffs made that mistake, they ended up getting $43,000 less than had last been offered. So a large difference there. It's kind of interesting. So this study was done in 2004, and it was following up on a 1964 study. These studies are hard to do, and they take a lot of time to get the data. And there's been a follow-up, and they found that the trend has continued, and with even greater error rates than in the older studies. Yes.
Is this related to all civil cases or just a particular cafeteria?
I can't answer that. They took a large. It was a large groups of types of civil cases, and then I think some were wintered out. You'd kind of have to look at the study to see what it was. I don't remember particularly. Bob, did you know the study I'm referring to?
I think it was all. I don't think it was limited to a certain area of law.
Yeah. Okay. Yes.
I'm curious, I'm aware that some mediators will associate a co-mediator for various reasons, whether it be level of expertise or area of expertise, or sometimes even to just balance the gender dynamics in the room. I'm curious if you ever do something like that, and if so, what's your thinking around those sorts of issues?
So, I haven't brought in a co-mediator in a private mediation. Usually the parties are concerned about cost.
Sure.
I've co-mediated quite a bit in the past on some of the court programs where they pair me with another mediator. In the early days, early in my practice of doing this, I first started working as a neutral in 1996 for the court in Marin, and it's hard for two people to mediate at once. When I first started, I would just really try to sit back and listen, see what the other person was doing. They were more experienced than I. Once I had some experience, I've worked with some people more than once in some of these programs. Some people I work well together with, some people I don't. You end up stepping on each other's toes. You can have different styles. There have been times where I've just cringed at what my co-mediator was saying. Like, wait, not yet. Like, it's important what is said and when it is said. And it was just like I'm very careful when I mediate not to give one side ideas or suggestions on how they could be litigating their case. I try to listen and help them resolve it. But sometimes you see someone missing something completely, and it's hard not to, but I don't. I've had co-mediators say things where I'm just like cringing, like, oh, wait. We're going to say that after we've gone to the other room and then come back here, then they'll be ready for that. And so it's hard to work with a co-mediator. If somebody asked me to co-mediate with them, I probably wouldn't turn them down. I don't look for co-mediators. If it's outside of a field of law, they're going to go to a mediator in that field of law. Any questions about anything? Yes.
How do you handle it if one party is represented by counsel and one is there in pro per?
Oh, good question. Thank you for asking that question. I have mediated, I think, a lot of cases where one side is improper compared to what most mediators see. So I've worked with a lot with impro people who represent themselves, and So there's different scenarios. You've got a litigated case where someone's representing themselves and the other side has an attorney. You've got litigated case where neither side has attorney. You've got pre-litigation before they filed a lawsuit where someone's improper. In those cases, one side may have already got an attorney, the other side doesn't. When one side has an attorney, one side doesn't. One of the things that happens is the improper might feel like the lawyer on the other side is going to pull the wool over their eyes somehow, and so you have to work with them on that. When I'm working with an improper, one of the things as a mediator, I can't give legal advice and I can't give case advice, and sometimes I see them doing things that hurt themselves, that's personally difficult. But I have to. I can't help them. I can't give them legal advice, and it's sometimes I don't want to say heartbreaking, but I'm unhappy to see where someone's missing something that could be, if they had a lawyer, they wouldn't miss. When I am working with an improper, I'll say, sometimes I come right up against the line of, am I giving them legal advice or not? I don't. If I get up to that point, and I try to stop short of that. You had a question. One second. Did that answer your question? Okay.
I have extremely limited experience. I'm about to ask you, is this legal and is this wise?
I won't answer if it's legal. If you're asking me if it's wise, you'd be the first, but go ahead.
Legal is perhaps not the right word. Instead of negotiating with, well, we're over here, he comes here, he comes here, there's another way to mediate. You say, here's my offer. You don't have to take it. But if you don't take it, the next offer you get from me will not be this good. It will be not lower as you're expecting, but higher.
Absolutely worst negotiating tactic. Any lawyer anywhere that will never settle a case, it has never settled a case. Every lawyer in this city will run out the door, will hang up on you when you try it.
If you walk into a mediation and you announce to the mediator that's what you're planning to do, what I meant by legal is with the mediator say, you can't do that in a mediation.
You can do whatever you want. I'm not here to tell you what you can do. In America, that kind of negotiating doesn't go very far. Okay? There are other cultures that negotiate different from us, okay, whereby until the deal is done, it can go any direction at all. So we might agree on one part of it, and we think we've got that locked down, and we move on to another issue. Well, if this other issue isn't going well, then side may, in other cultures, they're going to back out of the thing they've already agreed to. Or like you say, they're negotiating, then they don't like what they're seeing from the other side, so then they go backwards, they go the other way. If your demand, you're talking about a demand from a plaintiff. If your demand is going to go up, there needs to be a reason for it. Okay? So, for instance, a demand is made early. This is an early demand to settle the case. Now, the lawyer has put a ton of time into it and a ton of effort. And not just that they put time and effort into it, but the time and effort they've put into it has increased the value of their case because they've got new information, new evidence, a new theory. They found new cases that supports their case so that it's actually made their case better. Then with that information, they can say, well, with this new information, my demand is now going up. It still doesn't go over very well, but it happens.
Thank you.
Yes?
Well, two related comments on that. One, in ADA access cases where there's a threshold and someone can't roll in or anything needs doing that hasn't been done, a letter's been sent, 2 letters have been sent, nothing's been done. There are lawyers who take these cases regularly, and they work up a case, and they have an expert, and the expert goes out, and the expert looks over the premises. So by the time you get a complaint or a demand letter to the owner, let's say of the tenant, that lawyer is very likely to say, You can settle this case right now for $40,000. I'm making up a number, actually. It's not always that high, obviously. But, and if you don't want to do that, that's okay. I'll get my attorney's fees eventually, and we're going to win the case because it's plain and simple that you could have fixed it. You didn't. So I've seen that a lot as a representative of the owner of a property or as a mediator. The other comment is that there was a company. Do you remember? In the 60s or 70s or 80s, I forget. There was a large corporation in this country, and I can't remember who it is. So I'm not hiding it. I just forget. And they took the position, and this was because they litigated tons of cases. It might have been product liability cases. I'm not sure. But anyway, they took the position that anytime they were sued, they'd look it over and they'd make a proposal. And if you didn't take it, they're going to go to trial. Period. Now that's not, we're going to jack it up, but you're going to lose. They didn't always win, but they got a reputation among the lawyers who brought these cases that, gee, they're serious about this. They do a reasonable look. We might not like it, but they found that they got a lot of cases settled because of that absolute bright line, kind of thing.
Well, and I think plaintiff lawyers need to try cases so that the defense sees that they're going. So there's some teeth behind their demands that they will take cases to trial. Yeah.
Is there a code of ethics or professional responsibility, or sort of something similar to also a code of civil procedure for mediators?
There are court rules. The rules of court. Yes?
Do you have any favorite practice guides or anything that you recommend to your parties that come to you?
So for negotiating personal injury cases, there's a book called Making Money Talk. That's not bad. There's a handbook. I don't remember the author. It's called the Mediator's Handbook, and it's a paperback book.
Money what?
Mediator's Handbook.
Mediator's Handbook.
Oh, mediators.
That kind of gives an overview. Getting to Yes, famous book. There's a few out there. You start doing some research. Yes?
Just to comment on your previous thing about making sure that your adjuster is there, whether they can appear by phone. If you're going to agree that they appear by phone, find out where they are and when their business closes.
Right.
I ran into a problem where they were in like Minnesota and they
Yeah.
closed at 3 o'clock our time.
It's frequently the case. And so what you try to make sure is that the adjuster has a mobile phone, that counsel has the adjuster's mobile number, and that the adjuster's agreed to take their calls. I've had cases where, it's 8 o'clock back east and the adjuster's home with their family, but they helping us settle the case. And then I've had the worst situation where you can't get a hold of them and they're gone for the day.
Or where there's like a local office, here in the Bay Area that's open till 5. That's the adjuster that's there, but if they have to go beyond their authority level, the person is someplace else in front of them.
And even sometimes you get that when you have the adjuster there. There's an adjuster whose file it is, but that adjuster is at a mediation or somewhere in the Central Valley, and so you get an adjuster for the day who's got the file, but it's not really their file. And that's not extremely helpful. Sometimes when I allow an adjuster to appear by phone, depending on the case, I will want the adjuster present on the phone during the entire mediation, not sitting at her desk or his desk, and when the attorney calls, just talking to the attorney about case values or offers and demands, but actually keep them listening and participating the whole time. So I'll do that sometimes, depends. You had a question? Yes?
Yeah. When you reach an agreement during mediation, do you write all this up and do the lawyers review it, or is this just strictly between the parties and the lawyers are no longer involved at that point, or how do you
if you have lawyers, they're going to be involved. They're going to sign it. We'll write up a memo of understanding or a memorandum of settlement, something that gives just the very basics. And then the lawyers usually agree among themselves who's going to do the, we'll agree at the time, but one side or the other will usually write the complete settlement agreement. And the memo of settlement will have a line in it that says this is going to be effective whether or not a more formal agreement is completed. And it has the basic things in it that most of the lawyers know of.
Have you ever had situations where the agreement that these parties arrived at are very different from what either lawyer wanted, and is there a problem with that, or?
It's only a problem with that if, their lawyer is talking them out of it. Doesn't usually when someone has a lawyer, they have a lawyer for a reason, and they're going to listen to their lawyer. They're paying their lawyer. So if they have lawyers, it doesn't usually settle at something completely different from what the lawyer is advising their client. I mean, sometimes the client will just say, you know what, I don't want to do it that way, and they do it their own way, and then the lawyer's, okay, what are they going to do? Is that what you're asking?
Because what I'm curious about is when people are in litigation and they decide, we're going to mediate, well, it seems like they're not satisfied with the situation that they've gotten themselves in with the lawyer or with the other party or whatever. So it just seems like that they should be able to just make their decision, and the lawyer is like out of the picture. I'm just wondering about what the relationship is and how that's managed.
So I don't really do too much managing of the relationship between the lawyer and the client. I'm not going to interfere with a lawyer's relationship with his client. In terms of, I will talk to them, in terms of helping them evaluate an offer or demand or so forth. But I'm not going to, it's almost like I'm mediating their discussions. I'm not going to involve myself in a lawyer's relationship with his client. That's not my position, not really appropriate for me. Yeah.
I'm trying to square what I heard you say in terms of having full disclosure as best as parties or counsel are willing to do, and then coupled with the thought of providing a confidential mediation brief. And can you give us a scenario where that might be appropriate, or what somebody's reason might be?
If a lawyer knows something about, it has a witness. There's no other witnesses, and no one knows a witness. Now a lawyer has a witness, for instance, who really helps their case.
Right. Okay.
Right. They might not want to tell the other side just yet. It usually comes up where a lawyer is holding back for trial strategy purposes. Right. But if we're trying to get it resolved, and this is going to help you with the value of your case, let them know. There's no surprise in trial anyways. Right. You're going to have to let them know before trial anyways. So, yeah. Yes?
Just confirming, is this Jennifer Beer?
Pardon me?
The mediator, Jennifer Beer?
Is who Jennifer Beer?
The author of the Mediator's Handbook you mentioned.
Oh. I'm not sure. Might be. That sounds kind of familiar. Anything else? We're done. Thank you all for coming. If I can help you, feel free to give me a call if I can help you settle cases, so forth.